legal framework of the United States, Canada, and Mexico as a North American region. But there were some materials and some guidance that I took that can be applied in any of our countries, but with the specific follow-up on the legal framework of each country. So when we talk about legal compliance, we want to make sure that the concept that we understand at this point is how a facility or being you as the regulator, how a facility can go about ensuring whether it's compliant with legal requirements in the jurisdiction in which it operates. Meaning that we have listened to the legal framework on each of the country presentations. I think it's one of the main issues that we share, but we also is one of the issues that we have more points that apply in some countries and some other are not. It's a difficult topic to have a common ground, but in general, the concept of this module is how the companies comply with legal requirements. And there is some important considerations for the industry regarding occupational health and safety, environmental approval, transboundary movement. There's not just one ministry that is in charge of all legal requirements. We mostly hear from environment, but if we think about transport permits, health and safety, occupational labor ministries, it gets more complicated. I want to make a special note on this module that does not provide a specific guideline for a country or for North America even. It just gives you a recommendation on legal compliance activities, and it's always recommended to contact national, state, or local authorities if you have any questions on legal compliance. Probably you are the contact for environment. That's why this special note is here for this module. So if you remember the morning presentation on modules 1 through 4, there's environmental sound management and the Basel Convention. It's number 4, legal requirements that identify, access, and strive to fulfill applicable legal requirements. For example, there are some laws, there are decrees, some regulatory agencies are different. I know, for example, here we have from Costa Rica health. So there are different actors in this regulatory and legal compliance issue. It's different in each country. The refurbishing facilities need to comply local, state, provincial, territorial, national laws, and some other international if you are a signer of international conventions. But as you see, the United States has different enforcement and legal application for each state. Latin America has another story, Africa and Asia as well. So I think you can even talk, even if it's in the same country, you need to look for differences in the legal compliance. What are the benefits? That's the other modules. I explained that the benefits of environmental sound management in the end is to protect the environment and the health. When you are following the regulation, usually you have a productive workplace. It's applicable for our offices. You can avoid penalties if your labor ministry also gets you a fine or something. You can have even closure. Companies, I think they maintain a reputation. I think several of the companies, or the company that we will look tomorrow, has a reputation, a good reputation, because Carlos has invited us there, so I assume they have a good reputation. The consideration as a provider or as a client is also important when you comply with legal requirements. And there are some terms that when you talk probably in each of the countries as assurance, this module will try to give you some general idea of some of these concepts. And offering assurance means that you guarantee something, that you give confidence that you will be doing things right. You can assure that you do your work well. And in the case of a refurbishing or a recycling industry, the companies can offer a service following some steps that you know are correct. Many people don't have the knowledge on the different steps that a company needs to assure, but we as representatives of the government, and we look maybe in audits and different applications of this knowledge, we need to know what the refurbishing and recycling industry needs to comply. And also certification programs I've heard are of interest and usually require legal compliance. Not only R2 or stewards, but there are other programs, and usually one of the sections in the requirements is to comply with the legal requirements in the area they are located. One of the best practices that the guidelines suggest is to implement this legal compliance with a systematic approach. Again, it's a step-by-step process. It's better you have everything in a certain order, so you can be sure that you comply correctly. Again, this is a little small, but you have the presentation. But for the general legal compliance in our environmental sound management, it's suggested that follows 8 steps that come around at some point, because you need to develop certain procedures for legal requirements. If you don't know what you need to comply, how we are going to do that. Then you need to identify what applies to you and document them. You remember we saw earlier that record keeping is very important. So document everything. It's also a good practice in environmental sound management. Also, you need to communicate applicable legal requirements. I don't know if this is for everyone, but if you don't, you just can't say, I didn't know I had to comply, and they will not give you the fine. The ignorance of this is not a reason not to give you a fine, for example. Number 4 is the implementation of measurements to comply with legal requirements. If you need to measure something, you may have to do other activities to comply, not just record everything. When you develop procedures to monitor compliance, it's again going to the records. If you show that you have developed these procedures for compliance, and to see that each year, if you have to renew a permit, for example, you have to have this procedure. Then you have to monitor that it's actually getting done. The evidence comes again here, and review if there are no new changes or new regulation that you need to follow. We have received in our office complaints sometimes of the manufacturers, and they don't know that now certain standard is in action, so they're starting to go again to that they didn't know. So this part with the review, it's an obligation also, especially for companies, and I think communication is very different media on the websites or forums or where people need to start checking. And it's also the job of the legal department, I guess, in companies to be aware of this. So now we're going to listen to Christine talk about legal compliance in Washington.
So if you'd like to become a collector or a processor in Washington State, it's your responsibility, but you need to consider the local, state, and federal requirements. At the basic local level, we've spoken earlier about the zoning requirements. For the processors, zoning is important. We do look at the zoning, and that's also addressed in the audit. Usually our processors are located in the industrial or business parks. For collectors, we don't check unless there's a complaint receipt. It's still up to whoever's running the collection site to make sure that they are in compliance with the zoning restrictions. In Washington State, there is an online questionnaire that I'm not even sure how many people actually know about, but hopefully if you're Googling what permits might I need for this activity, then maybe this questionnaire will show up. I didn't even know it existed. But I went ahead and filled it out, pretending I was going to be a collector, and it's fairly accurate. It gets you to who your local health jurisdiction is, and it directs you to the Department of Ecology, who is the main agency overseeing the management of e-waste. And then they should be able to help you get any contact that you need at the national level. So these are a few of our state agencies that participate in overseeing the e-waste industry. A lot of these apply to any business in Washington State. The Department of Ecology, who I work for specifically, is involved with the e-waste management. If you are handling e-waste, you will either be exempt. If you're fully recycling it, you'll be exempt, but you'll still be overseen by our hazardous waste program. Or you have the option of also being in the eCycle Washington program. It's not mandatory. So if you do decide just to dispose of e-waste, though, you are then going to need to abide by the dangerous waste regulations, which means a lot more reporting, permitting fees. So the recycling is really encouraged. If you'd like to be a transporter in the eCycle Washington program, you're going to need to contract with our state-run program. They're called the WMMFA, Washington Materials Management Financing Authority, and that's the board that is composed of the collectors, the recycler, and the producers. So you'll need to have a contract with the WMMFA and make sure that you are annually registered with our program. And it's similar to if you were a collector, you need to have a contract with the WMMFA, and you also need to register annually with our program. This is an example of that compensation agreement that transporters and collectors fill out, and we don't actually get to see what the compensation amount is. It's competitive, and they don't disclose that to us or to any of the other collectors amongst themselves, but I've seen it range from 7 cents a pound to 10 cents a pound. Collectors have to meet certain performance standards if they'd like to be in an eCycle program. If you have a drop-off location, it has to have manned hours. It can't just be opened at any time for people just to drive by and drop off material. All of the handling needs to be stored in an enclosed area. No dismantling is allowed. Everything that's collected needs to be submitted into the program. They can't pick out any of the valuable materials. We also require that our eCycle collection sites post eCycle Washington information. A lot of the public, they want to know where their material going, and so they are required to put that information out there. And then they also have to allow ecology access to the collection sites. The WMMFA also has their own set of standards that this is not explicitly in the law, but it is required if you want to be an eCycle Washington collector. We spoke earlier about the signed covered entity verification log, and that doesn't apply to all collectors, only if they suspect their collection collecting materials from entities who are not part of the program. All the material has to be palletized and sorted by type. You need to keep your bill of lading, and you can only use the e-cycle transporter and the e-cycle processor that the WMFA has said that you can use according to that bill of lading. You can't just go to the list as a collector and pick out who you want to work with. It is assigned by the WMFA. Processors are also similar, that you have your contract with the WMFA, and you also register annually. You need to meet the performance standards and provide your annual compliance audit report that's showing you're meeting the performance standards. This is a list of the preferred performance standards. We have two sets. There's the standard and the preferred, but because our processors already meet the preferred standards, the WMFA has decided to only work with businesses who meet all of the preferred standards. And very directly it says you have to meet the legal requirements. So not only of Washington State, but you have to meet the legal requirements of any other state you may be transporting through, or you also have to meet the legal requirements of any other countries you may be exporting to. And if you have any violations, you're also required to report those to e-cycle Washington within 60 days, and also let us know how you're going to be correcting any violations. So it's very unusual that we issue any fines to our collectors. If they're not meeting those performance standards, then what we do is just say that they're invalid to be in the program, and that's usually a large enough incentive that they'll correct anything that is not in compliance because they want to be compensated for their collection. So we have not had to issue any penalties. Just worry about it. Processors are a little bit different because if the processor is out of compliance, we will not fine the processor directly. We will actually fine the WMFA because it's their responsibility to make sure that whoever is recycling their material is in compliance. The WMFA has the opportunity to work with that processor to make sure that they get back into compliance if they want to, or they can stop doing business with them, but they will still be responsible for any material they have sent there. They are still responsible for making sure it does get properly recycled.
Another concept in legal compliance is the due diligence, is to demonstrate that all reasonable efforts have been taken with a certain standard of care, meaning that if you show that you took care, for example, that occupational health and safety are requirements are fulfilled, we will be doing some due diligence to develop written policies, to monitor in the workplace, and to develop, for example, if you develop accident investigation and reporting system, if you show that there are all these activities are taking place, you do due diligence, you follow or comply with due diligence. There's a best practice that the stakeholders should be aware of how they can demonstrate the due diligence. In this case, we could be companies, or we can do the same, taking care of how we comply and took care of really complying with applicable regulations. I think Christine has said some examples of penalties. It's just an example of Canada, I think, in the guidelines, that they show that they failed to control death exposure to workers, and they fined the company with over $67,000. So they failed to implement controls, to measure effectivity in the ventilation system. It was very obvious that the workers didn't have appropriate training, so that shows what can go wrong at this point. It's not just, it's not just the money, it's also the health of the workers. Yeah, this is another one of Washington.
We're good.
So this was just another example. I mentioned that our e-cycle collector, we may not issue fines. This is a collection facility for just all sorts of different household material, used oil, lamps, electronics. And our hazardous waste program received a complaint, so they went out to inspect, and then they notified us that there was improper storage of the electronics and the televisions. And so we suspended them from the program, and they're given the opportunity to fix it. So that even though they may not receive fines from the East Washington program, there's still the potential to receive fines from the hazardous waste program, and that could be $10,000 per violation per day. So I didn't want to give the impression that there's no penalties that might happen. It may not happen under the e-cycle program, but it will happen potentially under the hazardous waste program.
And then to be closing up this session, we will have Matt talking about an example of California. Thank you.
So you heard a little bit this morning about this, but most of the structure is very similar to what Washington has as far as the inspection and requirements that they have to manage the materials. So we have an annual inspection for all the recyclers. We have pretty prescriptive regulations. Thou shalt do this, thou shalt do that. Even though there's somewhat flexible in how you do them within that parameter. So we want you to have standard operating procedures. These are harkening right back to the ESM process. So you know what you're supposed to do, you check it, and you keep planning and reevaluate and make sure it works. So then there's feedback mechanism and regulatory compliance. So So we talked earlier about training requirements, waste tracking, sound management to reduce releases. We want you to respond if you do make a mistake. Obviously, don't leave it there. On the business side, there's annual training, specific to job tasks we mentioned again this morning. We want you to track the material, where it's coming from, where it's going. We want you to have standard operating procedures for every task. We want you to evaluate and monitor that. So, can ESM prevent this? Most of the time. Every once in a while, the guy hits the gas pedal instead of the brake pedal, and he's going to smash into something. So, you have accidents, but you have sound management. Maybe there's a forklift training that this person's supposed to take annually. So that'll prevent some of these things. You have how you store the material outside or wherever you store it, aisle space, those kind of things. There's all these issues you got to look at. But the question we have when we walk into the facility is, how long has that been like that? Is that today, 2 weeks? We have a concept in our rules that says they failed to prevent a release, and that's a violation. And depending on if they've done it before, we have various classifications of violations. Class 1 is the worst, then class 2, and then minor. So it escalates up if you keep repeating and being recalcitrant for not doing something correctly. So for e-waste, our fine structure is a little different than basic hazardous waste. We try not to assess $25,000 per violation per day for e-waste violations because it's a universal waste and we're trying to make the system work a little better. So if it was still a repeat violation and a little more onerous, we may charge you $4,000 or something like that. So we have issued quite a few fines for lots of different facilities, and we've done some corrective behavior without issuing any fines. So there's lots of different ways depending on the facility's ability and their responsiveness. So if you tell somebody to do something and they do it, we want to work with them. So this person had not cleaned this up. It had been sitting there for quite a while, so that was a problem. So we considered it a class 1. So there was a fine for this one. ESN can prevent this from happening more often, obviously. So it's training and reinforced that way. So.
Thank you, Matt. And to finish this discussion on legal compliance, just to take a step back on the downstream processor. The downstream processor facilities should also comply with applicable legal requirements, not just because if a big company gets comply with everything, but the downstream processor doesn't, you probably have a fault in there. So to take care and to be sure the materials has processed correctly. The environmental approvals and reporting, they usually are necessary if you want to maintain operations, to store, transfer, and dispose waste. If you release pollutants at some point and engage in specific refurbishing or recycling activities, you will probably need, I'm sure, legal requirements. These activities usually are regulated in all of our countries at some point. There are some regulations that are in different countries, as the pollutant release and transfer registry.
Here's the software. I'm just about to finish. But the pollutant release and transfer register is one way that the law requires to let you do some activities of recycling. There are some national emission standards or pollutant discharge elimination systems permits, hazardous waste permits, and of course international agreements that are the usual legal compliance in most of our countries. Maybe this in the Q&A part we can share, if someone wants to share any tips or any information on how to ensure legal compliance in their countries. You're more than welcome to do that. Just to take away the takeaway messages for this last module, we have 6 points. They're a little short, but small, but the legal requirements have been established to save human health and environment. We know that some limits are beyond that. And to follow all the safety regulations will result in a productive workplace. You need to avoid penalties. I was impressed with some of the rates of the penalties you said. The facilities can establish a reputation with the clients, are more likely to consider if they have authorization and all their papers documented, and if they have tools to know, to assure investment, and to know that all the materials in the cycle, when they are in the end of life cycle, are managed correctly. So it's useful to operate in compliance with the law, but we have also voluntary programs. So we don't need to stop there, but this is a very huge part of the environmental sound management. So I thank you very much, and maybe we can proceed with the Q&A.
Thank you very much, Renee. We're going to open up to questions and answers. Anybody has any questions? Okay, Garth.
This is a question for Christine. Christine, I'm wondering if you could financial assurance requirements that may be in place for recyclers in Washington? And then secondly, just on another topic, to follow up on one of the points you made yesterday about requiring the recyclers to have both R2 and e-stewards. I'm just wondering whether the Department of Ecology's and has put any thought into the fact that those two standards seem to be actually diverging in terms of some of the requirements, expectations, what's allowed, what's not allowed, and in some cases maybe in direct conflict. So I'm just kind of curious about how you're sorting that out. I think that that's something that a lot of the state agencies are wrestling with as we support certification. It was very easy when R2 and E2